Baron Cohen.
Hi, good afternoon, everybody. Everyone can hear me. I've got Bhupender as well, my colleague on the line. If we can just test everyone's cameras, mic, speaker, 5 minutes, I think that will be helpful. Bhupender.
Yeah, hi everyone. Good morning. Everyone, can you please open your mic as well as the camera so that we can check everyone's mic and the camera is working fine.
Yeah.
Thanks a lot.
Hi, hello. Good morning.
Hello, guys. Good morning.
Hello.
Benadeti, can you please open your mic?
Hello, can you hear me?
Yes, I can hear you. I can hear you.
Hello, can you
Hi,
hear me?
Devinti, ma'am. Hi, I can see you. Uh, hello, Mariam. Mariam, can you please open your mic and camera?
Just a minute.
Okay, sure. I can hear you. I think everyone's mic and the camera is working fine. I think, yeah. Fadil, can you please open your mic? Khadija?
Hello, can you hear me?
Yeah, totally fine. Yeah, I think everyone's mic is working fine right now. So, yeah. Soon we can start the process. Thank you, guys. Thank you.
Sorry, Miss Sen, can you hear me?
Yes, I can.
Hello, good morning. Hi, my name's Sushil from London. Hi,
Hi.
I'm one of the judges. Good to see you. I think you're judging with me. I don't know if we've
Yes.
got one of the other judges here, but from what I'm seeing, I think we need to ask the teams how they're splitting the advocacy. I don't know whether we start doing that now if everyone's online, because I think they need to start presenting, don't they?
Yes, I think so. I was just gonna say maybe we can start.
Yeah.
Um, are all the teams here now?
Yes.
So
Well,
can we just check who's on and whether both the claimant and defendant teams are on?
the claimant team is here. The claimant team.
And who are the advocates for the claimant?
For the claimant, I will be the senior claimant, the senior counsel, and Kabisha will be my junior counsel as well.
Khadija.
Kabisha.
Kabisha. Okay. Why can't I see online? Okay. And who's here for the defendant?
We are here for the defendants, me and Khadija Raifa.
Okay. All right. So if I've got this right, I think the claimant. So who's going to open? Is the claimant going to open the case?
Yes, I will be opening the case.
All right. And I think each team. Miss Sen, sorry, do forgive me if I'm missing something, but I think they've got 45 minutes each, haven't they?
Yeah,
That's
exactly.
correct.
Okay. Obviously, between the senior and junior advocates, that's a matter for you how you devise your time. And I think in terms of questions, I think we can ask questions after you make your submissions, Miss Sen. Is that right, or can we ask the questions as they go along?
I think we can ask as they go along. I mean, we can see how it goes, but unless you have a preference to the contrary.
No, we can. Yeah. No, we can ask them as they go along. I think that's probably better, isn't it?
Yes, I think so too.
All right, fine. Okay. I think there was one other judge that was supposed to be with us, but I can't see her online. So, I think we'll make a start.
Yes, I think it's best that we start.
Yeah. Okay. So let's hear from the claimant first, then.
All right. May it please the court, my name is Kauthar Belkacir, and I'll be the senior counsel for the claimant Artemis, and I'll be accompanied by Kabisha Shuling, acting as the junior counsel for the claimant. Before I move on with my submissions, would your honors benefit from the facts of the case?
No, I think we've read the summary. So the skeleton argument, I think, sets out what the background is and what the issues are. So no, don't worry about summarizing the case. I think it's set out in the skeleton.
All right. Your honors, we submit that the key issue in this claim is whether Solidream Incorporated is liable to Ms. Artemis Astotia by way of committing a tort of negligence and by way of breaching their contract. Your honors, I will present our case under two distinct submissions. The first being that Solidream breached their duty by acting below the standard of care and caused the claimants, and the second one being the contractual breach of the defendant. Your honor, may I proceed with the first submission?
Yes, of course.
Firstly, Your Honor, the DIFC law of obligations mentions that a defendant would be liable in negligence if they had a duty of care, breached it, causing loss to the claimant. Therefore, Your Honor, let me first consider the liability in tort and illustrate on the duty of care owed by Solidream Incorporated to its passengers, including Artemis. Under Article 18, subsection 1 of the DIFC Law of Obligations, which can be found in the Claimant Bundle, page 21, the duty is grounded in three fundamental components. First, the feasibility, proximity, fairness, justice, and reasonableness. Firstly, given the nature of the Vulcan virus and its known transmission risks, it was reasonably foreseeable that launching a spacecraft without definitive confirmation of all passengers' health status could result in infection and subsequent spread. The very essence of foreseeability lies in the anticipation of risk, a risk that was glaringly apparent, yet ignored by Solodream Incorporated. And second of all, the relationship between Solodream and Artemis is not merely a contractual, but inherently proximal. As a service provider, Solodream engaged directly with Artemis, thus establishing a clear and sufficient closeness that mandates a duty of care. This is not a distant or abstract relationship. It is direct and personal, intensifying the duty owed. And lastly, it is not only just fair um, and just, but also reasonable to expect that Solodream, a commercial spaceflight operator, would uphold a high standard of care, particularly in maintaining robust, safety protocols. The nature of commercial spaceflights, um, coupled with the known danger of the Vulcan virus, unequivocally necessitates an elevated standard of care, which in this case, um, um, Solodream has failed to meet their reasonable standard. These three pillars underpin the undeniable duty of care that Solodream owed to Artemis and to all passengers aboard. Their failure in this regard is not merely an oversight, but a fundamental breach of duty required by the law and by the ethics of their industry. Moreover, Your Honor, as per Article 21, subsection 1 and subsection 2 of the same law, available in the claimant's bundle, page 21, reasonable care encompasses actions that a prudent operator would undertake under similar circumstances. Instead of ensuring all PCR test results were received, which is critical in ascertaining the health status of the passengers amidst a global pandemic, Soldium Incorporated, gambling with health and safety, opted to rely on a lateral flow test. These tests are notably less reliable, particularly for detecting an asymptomatic infections, which in this instance led to Artemis unknowingly boarding the spacecraft while infected.
Can I just pause you there one second? I just have one question. It might be better I ask this question now. Your client was suffering from headaches, wasn't she?
Yes, she was.
So does she accept that she did not disclose that to the defendant at any stage?
Yes, she does. However, the headaches are not considered a significant illness to mention, as it is not important in this case.
You say that. Is that one of the symptoms? Is that one of the symptoms that is that one of the symptoms of the Vulcan virus, headaches?
I don't believe they are one of the symptoms, Your Honor.
Are you aware whether that's one of the common symptoms, suffering from headaches, if you have that virus?
No.
It's not. Okay.
May I continue?
I just wanted to clarify. Yeah, please. Yeah.
From this expected level of care, as highlighted in Article 21, subsection 3 and subsection 4 of the court bundle, which describes the standard characteristics of skilled entities possessing special skills relevant to commercial spaceflight, Solodream Incorporated failed in its duty. Your Honor, I would like to draw your attention to the case of Bolton and Fern Hospital Management Committee, decided in 1957, reported in the second volume in All England Law Reports, page 118. You may find this case on page 8 of the court bundle. Would Your Honors benefit from the facts of this case?
No, it's set out in your skeleton, isn't it? I think.
Yes, it is.
Yeah.
Your Honor, in this case, the court established that a professional must act reasonably in accordance with the practices in that field. I would like to highlight that the standard is clearly one of adherence to stringent safety protocols, especially in high-risk industries such as space travel. However, the defendant failed to do so by relying on a lateral flow test and departing, therefore causing the spread of this virus among all passengers, including my client. However, the defendant, moreover, Your Honor, taking into account the causation principle, the causal link between Soul Dream's decision to launch without confirmed negative PCR test results and Ms. Athotia's losses is unequivocally direct and substantial. Had Solar Dream delayed the launch until receiving all the test results, Ms. Athotia would not have boarded while infected with the variant, nor would she have exposed other passengers. This failure is the substantial cause not only to the health deterioration among the passengers, but also directly led to the premature termination of the retreat, preventing Ms. Athotia from filming her planned space yoga series. Additionally, Your Honor, Article 20 of the Law of Obligations concerns economic loss, which you may find in page 20 of the claimant's bundle. In applying it, Soul Dream's liability for economic loss is evident. Soul Dream had a duty to ensure the safety and reliability of its services, which Ms. Astothia relied upon when planning to film her space yoga series, which this reliance was reasonable, given Soul Dream's professional status and the promotional assurances of a
Counsel, if I
yes.
may just stop you for a minute. This clause 20 that you're talking about refers to Article 17 of that same law. But I don't see Article 17 in your bundle. Can you just tell us what Article 17 says?
Article 17 mentions how a duty of care is owed and how it is breached, and negligence is established in a sense.
But isn't that Article 18?
No, that is Article 17.
All right.
Um, yes, Your Honors, this reliance was reasonable given Soul Dream's professional status, as I said before, and by launching prematurely and without the confirmed PCR results, Soul Dream breached this duty, directly causing Ms. Athotia economic loss, as she could not perform her planned professional activities, nor could she experience the service promised. As such, Your Honors, the counsel for the claimant submits that the defendant is liable for in tort, as they breached the duty owed and caused the claimant's loss. May I proceed with the second submission, Your Honors?
Can I just ask one very, very quick question? You may not know the answer to this, but I'm just very curious. Do you know how much time passed from the launch to when the PCR results were released? I mean, how much window was there from the launch to when the PCR was finally released? Do you know?
I believe that was not disclosed in the facts that we had.
Okay. Is that just you're not aware of the window that passed
I'm
from?
not aware of.
You're not aware. Okay, that's fine.
May I move on with the second submission?
Of course. Yeah.
Thank you. Your Honors, page 19 of the claimant's bundle represents Article 77 of the DIFC contract law, which defines non-performance as failing to fulfill any contractual obligations, including defective or late performance. Under the agreement, Solar Dream committed to ensuring a safe and successful flight. However, they failed to meet this obligation, deciding not to reschedule the flight despite the risks posed by the fast-spreading variant. Your Honor's safety should have been prioritized, particularly by waiting for the test results to confirm all passengers could safely participate in the activity proposed.
Counsel, can you please point me to the clause of the agreement which says that safety should have been prioritized?
Under the assumption of risk section in the contract, Your Honor.
Which clause is that?
One second, Your Honor.
clause 4, I take it.
I believe so. I'm having troubles with the PDF. Sorry.
Yeah, I think it is.
Yeah,
It is
yeah, I
for it.
think.
My apologies.
No, that's
Yes,
all right.
clause
Um,
4, as I read it, says that your client was aware that there were certain risks uh, inherent in the space travel that she agreed to pay for.
yes.
But how do you, and it also says that your client agreed and acknowledged that there were potential health risks associated. But so how do you read that to say that the defendant had a duty to, as you say, put safety above all?
Your Honor, the defendant had duty to put safety above all. However, they did not, as they did uh, not wait for the PCR test result, which was a significant test result for the plane, for the spacecraft to launch. Yeah. Um, The agreement highlights the importance of the passenger's health, as I said before. They required medical evaluations and histories to assess the eligibility for the flight. Soldrim neglected this duty by proceeding with the flight without confirming the PCR test results, and by that comprising passenger safety. Uh, the agreement includes the assumption risk section, acknowledging certain and unavoidable risks, as I have mentioned before. However, the risk of the COVID-19 infection was foreseeable, and the medical staff should have approved the launch based solely on lateral flow. They, they launched the spacecraft based on the lateral flow tests. This oversight led to the mission being cut short and passengers suffering from illness, ultimately failing to deliver the promised spaceflight experience. Additionally, Article 59 of the contract law, which is present in page 19 of the claimant's bundle, explicitly states that a party must achieve specific results when so obligated and exerts best efforts as would a reasonable person under similar circumstances. Soldrim's decision to launch without the test results fell far below the standard of care expected in the space travel industry as established previously, and this breach directly led to the mission being cut short and deprived Ms. Astutia and indeed all passengers of the fully space yoga experience as they promised and entitled to, uh, as they were entitled to under the contract. Once the flight was underway and it was discovered that my client was infected with the virus, the measures taken by Soldrim were insufficient and if ineffective, as evidenced by the rapid spread of the virus among all on board. This failure exacerbated the situation, leading to severe health risks and the inability of my client to carry out her professional duties, which were planned specifically around the unique environment promised by this flight. Your Honor, Article 80 of the Contract Law, page 19 of the bundle, supports that even if a non performing party attempts to cure their failure, the aggrieved party retains a right to claim damages for any harm caused by the delay and by the inadequacy of the cure itself. The measures taken by Soul Dream post-infection notification were too little and too late, and did not prevent the spread of the virus, nor did they salvage the mission's intended purpose. Your Honor, under Article 86, Ms. Asotia has the right to terminate the contract due to fundamental non-performance. Soul Dream's actions not only substantially deprived her of what she was and entitled to expect under the contract, but also demonstrated a disregard for contractual obligations central to the mission's success. Their failure gives substantial reasons to believe that the future reliance on Soul Dream's performance is untenable. Therefore, Your Honor, based on the evidence and the application of the law,
Sorry,
it is
Counsel, just to pause you there. The problem I have with this argument that you're running is, if you read Article 86, it says that the obligation which is not being performed is of essence under the contract. but you need to then link what you're saying with the contractor showing that their performance of a PCR test was of essence to the performance of the contract itself.
Yes.
So can you assist me with that?
Yes. The defendant did not complete the contract or did not perform their contract due to uh, not not completing the PCR test or not waiting for the PCR test results, and therefore, uh, as I said before, gambling with the safety of the passengers, and also they, as a result of that, Miss Asotia did not perform the activity that was promised under the contract. Um, and therefore, we seek the court's for favorable decision to find Soul Dream Incorporated liable under both tort and contract, and request damages in the amount of 15 million US dollars for refunds and compensatory damages for the losses incurred. And unless I may assist further, Your Honors, thank you for considering my submissions.
Thank you very much indeed. Thank you. We're now going to hear from your colleague. Is there a junior counsel who's going to be making submissions for the claimant?
Your Honor, I believe it is the senior defendant that has to submit now.
Okay, we're going in that order. Yeah, sure.
Good morning. Can you hear me?
Yes.
Okay. I'll begin. May it please the court, my name is Bernadette Woyo, and I'll be the senior counselor for the defendant, Dream Incorporated, alongside my junior counselor, Khadija Refa. Your Honor, the time allocation for the defense side is 15 minutes on the claim, 15 on the counterclaim, and 5 on each on the rebuttal side. Your Honors, may I proceed with our first issue?
Yes, please.
Okay, our first issue is in relation with denial of liability. Starting with medical liability, the defense relies on Article 17 of the Federal Decree Law number 4 of 2016 on medical liability that states on Clause 2 that medical liability shall not be established if the harm is caused by the patient's own action due to his or her refusal to receive treatment or to follow the medical instructions issued by the physicians, or if the harm is caused by some external reason. Therefore, due to Ms. Atimer's failure to disclose her medical history to the specialist doctors, this resulted in her not receiving adequate medical treatment before the situation had worsened. Her failure to disclose the medical
Counselor,
history.
may I just pause you there?
Yes.
Federal Decree Law number 4 of 2016 that you referred to
Yes.
is a UAE onshore law. Is that correct?
Yes, that's correct.
Now, is that applicable in the DIFC?
It is because common law. It is a common law decree law.
But isn't the onshore UAE a civil law jurisdiction? And therefore, isn't the federal law isn't this a civil law statute that you're quoting?
We're also using it as a persuasive law to show how the other legal state systems have dealt with the issues.
Yes. Okay, because could you please remind me the agreement that you had with the claimant? What was the governing law of that agreement?
Sorry, can you please repeat?
What was the governing law of the agreement that you had with the claimant?
It was DIFC law that we
Yes.
had.
So this is so you agree that the statute you're relying on is not a DIFC law and is not applicable to the DIFC.
It is not a DIFC law, but therefore it may apply in some instances within the DIFC. It is essential to consult specific laws and regulations to the DIFC to determine their applicability in a particular situation.
Okay.
Okay. Your Honor, may I continue?
Yes, please.
Okay. Her failure to disclose the medical history deprived the doctors of crucial information necessary for accurate diagnosis and treatment, thus absolving them of liability. The supporting case is Bolton versus Prime Hospital Management Committee in 1957. Your Honor, would you like a brief of the facts of the case?
No, it's all settled. Don't worry.
All right, okay. We made this our supporting case because the judge laid down the typical rule for assessing the appropriate standard of reasonable care in negligence cases involving skilled professionals. It established the Bolim test that if a doctor reaches the standard of responsible body of medical opinion, he or she is not negligent. Your Honor, may I proceed with my second submission?
Yeah, can I just very quickly? Is your case, is the defendant's case really, is that the non-disclosure of the headaches is really your main point, isn't it? Is that your main crux of your defence, that the non-disclosure of her chronic headaches, which she suffered for many years, that in essence has prevented you from carrying out your duties properly? Is that the
Yes,
case?
yes, that's
Brilliant.
we're denying the medical liability that she is claiming that we are liable for her COVID-19.
Okay.
Yes. Okay. May I
Yeah,
proceed?
carry on. Yeah, please.
Okay. Your Honor, I ask the court to note that Solar Dream fulfilled its contractual obligations faithfully, providing the agreed upon space light experience while upholding safety standards. As such, Solar Dream holds no contractual liability for Ms. Atimer's loss of earnings as a YouTuber, resulting from her independent business pursuits, and any attempts to assert otherwise lack merit or legal basis. The contractual agreement between Solar Dream and Ms. Atimus was crafted and explicitly outlined the terms and conditions solely related to the spaceflight experience. This agreement described responsibilities, payment, cancellation, medical evaluation, and more. Nowhere within the scope of this agreement was there any explicit or implied contractual obligation on the part of Solar Dream to guarantee Ms. Atimus earnings as a YouTuber. Furthermore, it is crucial to underscore that Solar Dream's contractual obligations were diligently fulfilled in providing the spaceflight experience as promised, including comprehensive safety measures and medical evaluations to ensure passengers' well-being. Any loss of earnings incurred by Ms. Atimis due to her inability to film a series of space yoga sessions, which she had independently chosen to advertise, cannot be attributed to any contractual breach on the part of Solar Dream. Atimis' decision to promote and plan space yoga sessions was a personal venture unrelated to the contractual agreement with Solar Dream. While we empathize with her, any embarrassment she may have experienced due to the cancellation of these sessions, such repercussions do not establish a basis for contractual liability on the part of Solar Dream. Your Honor, may I proceed with the final submission, please?
Yes.
Much obligated. Furthermore, under denial of Furthermore, under denial of liability, we ask the court to note that Ms. Atimer's contributory negligence by failing to disclose relevant medical information and regulating basic medical protocols directly contributed to her conditions and absolves Solar Dream from sole responsibility. Ms. Atimer's negligence contributed to her injury and her inability to participate in the scheduled spaceflight. Despite being aware of the need to consult medical professionals and declare any medical conditions, she failed to fulfill these fundamental responsibilities. By neglecting to disclose important medical information and fulfilling to inform Solar Dream of changes in her health status, including the presence of COVID-19 symptoms, she knowingly placed herself and others at risk. The supporting case is Davis versus Mann in 1842. Your Honor, would you like the facts or should I proceed with the court ruling of this case?
No, just proceed, please. Unless Miss Sen would want to hear them, I don't need to hear the facts of the case.
Okay, sorry?
I'm good, you can proceed.
Okay, I'll proceed with the ruling of the case. The court ruled that if the plaintiff's own negligence contributed to their injury, they cannot recover damages from the defendant, or their damages may be reduced proportionally. In light of Ms. Atimer's contributory negligence and breach of duty to disclose her medical information, Solar Dream cannot be held responsible for the consequences of her actions. Any damages, losses incurred by Ms. Atimer should be apportioned accordingly based on the principles of contributory negligence. And with that, Your Honors, that concludes the defense claim.
Counsel,
Thank
if
you.
I may just pause you there, since we're on the issue of quantification, is there anything on the contract that you want to refer to or um, rely on to say how much, if we are inclined to at all grant damages to the claimant? If there's anything that you would want to rely on to assist us
Yes.
with the question of quantification?
Okay, if you turn to clause 5.2 under medical evaluation of the agreement, it states that the passenger is supposed to inform the operator if there is any changes in any medical symptoms. Ms. Atimes did not inform the operators and especially doctors. That's it's led her to being negligent of her own health as well.
That's the only clause you wish to uh, guide us to, right?
For now, Your Honors, if
All right.
anything comes up, we will be sure
Okay.
to mention.
Perfect. Thank you so much.
Okay. Yes,
Thank you
and
very
with
much.
that, Your Honor, that concludes the defense claim. Thank you.
Thank you. Who are we hearing from next?
I'll be starting my rebuttals. As your honors have mentioned, the law that was referred to by the defendant is not applicable in this court. However, taking its persuasive purpose, we dispute this. Counsel for the claimant submits that Ms. Asotia was justified in non-disclosure of her chronic headaches, and my learned junior will address this point shortly in her submissions. However, Your Honor, if we were to entertain Ms. Asotia's fault, it is necessary to acknowledge that Solodream was also negligent in their actions, thus making this a case of contributory negligence. Reasonable measures cannot be said to have been taken by the defendants in regards to COVID prevention protocols. The variant had been circulating for a while, and why did the defendant not take care to consistently take or take tests for the virus? Why was the test only done on the day of the launch? That simple action is grossly negligent at that point. It would be too late for any preventative actions to be taken. As they had done the medical examinations months prior, they could have carried out the PCR tests with ample time to get the results prior to the launch. Instead, they chose to wait until the day of the launch to carry out the tests and were forced to launch without the results as due to the short notice. That is negligent behavior as a company that should be as professional as Solodream must adhere to a higher standard of management and planning. Senior counsel for the defendant also said that they cannot be found liable in torts as they allegedly took reasonable measures to mitigate risks. However, this assertion overlooks the critical fact that Solodream proceeded with the flight despite not having received all PCR test results. This decision contravenes the spaceflight agreement stipulation that the flight may be rescheduled to ensure safety. The emergence of the Vulcan variant and its rapid spread characteristics necessitated a higher degree of caution, which Solodream failed to observe by relying on less thorough lateral flow tests instead of awaiting for the more definitive PCR test results. And this action directly contradicts the assertion of having taken all reasonable measures and constitutes a clear breach of duty by failing to ensure the safety of all passengers under heightened risk conditions. Your Honor, the defense argues that Solodream did not breach the contract since they followed the safety protocols and regulations, yet this overlooks whether the measures were effectively and timely executed during the COVID-19 outbreak. The contract required adaptation to heightened risks, allowing for flight rescheduling to ensure safety. Soul Dream was aware of the variant's rapid spread and lacking complete PCR test results, nonetheless proceeded with the flight. This decision violated the contract-specific stipulation for rescheduling under known significance and thereby comprising passenger safety. Additionally, the defense's emphasis on initial medical evaluations and quarantine measures uh, fails to account for their ineffectiveness, as the flight proceeded without the conclusive test results, directly breaching the contractual safety requirements. Your Honors, this concludes the rebuttal for the claimants.
Just one quick thing. You mentioned contributory negligence early in your rebuttal. Are you accepting that your client has been contributory negligent?
No, Your Honor, I've mentioned that it would be their contributory negligence, the defendants.
Right.
Yeah.
So your case still is that the defendant is expressly liable.
Yes.
Okay, thank you. Who are we hearing from next?
The senior defendant on the response to the rebuttal.
Yeah.
Okay.
Your Honor, may I ask to address the court on the second issue of breach of contract?
Yes,
Oh, no.
please.
The space flight agreement is a legally binding agreement between Solar Dream and Artemis Astrotia. The agreement clearly defined the terms and conditions of the space flight experience, including payment terms, cancellation provision, and risk assumption clauses. The passenger went through all of these agreed. According to the DIFC Contract Law 6 of 2004, Section 4 of the Contract Law says that contracts are legally binding it if they meet certain criteria, including offer, acceptance, consideration, and intention to create legal relation. The space flight agreement meets these requirements, making it enforceable. Artemis violated her contractual obligation by failing to disclose her chronic headache during the medical evaluation as required by the spaceflight agreement. According to Clause 5 of the spaceflight agreement, defines the passenger's obligation to undergo a medical examination and disclose any medical condition that might affect their fitness for space travel. Failure to disclose material information may result in a breach of contract. Article 9 of Federal Law Number 10 of 2008 of UAE emphasizes the obligation of patient, including providing accurate and complete information about their medical history, current condition, and any relevant details that may impact their treatment. And Artemis failed to provide the accurate and complete information. Patient must cooperate with the healthcare providers, follow their instruction and recommendation regarding medical treatment and care, and inform them of any changes in their condition of adverse reactions experienced during the treatment. Ms. Artemis' breach of patient responsibilities is evident in failure to adhere to established protocol outlined by Sheikh Khalifa Medical City Ajman. She had a duty of cooperate with healthcare providers during examination and procedures, provide accurate personal information when applying for medical care, and she should have to follow the therapeutical plan processed by physicians. By neglecting to discover her complete medical history and withholding information from specialized professionals, Ms. Astrothia violated these fundamental patient obligations. Ms. Ms. Astrothia action breached UAE law and medical ethics rules, risking the safety and well-being of herself and the other participant and crew in the space retreat. She did not reveal her complete medical history, restricting healthcare professional ability to assess her condition and make informed judgments. This breach of trust risks the patient's provide relationship and medical intervention efficiency, and it will impact on care quality. Without complete information, healthcare providers may unable to develop a comprehensive treatment plan or anticipate potential complications, This can compromise the quality of care received by patient. Solatrim cannot be held fully responsible for the impact of Ms. Astrothia action because she failed to meet her commitment to deliver correct medical information. That's all, Your Honor.
Listen, can I just ask one question at this stage? Or move on? What do you say about the argument that the lateral flow tests were not ever going to be accurate and they should have used a much more better PCR type of test early on? What do you want to say about that?
Solar have conducted a lot of tests, including lateral tests, KBZ, and MRZ. So they have conducted every test, and also Artemis doctor. He is a retired NASA medical officer, so he knows what all procedures he has to take. Like he is aware of what are things, what are tests he should have take, right? So he have done everything correctly. He did his duty on a correct way.
All right. Okay. Thanks. I think we've heard from everyone now, haven't we? Is there somebody else that we need to hear from?
Yes, the counterclaim has to be started now.
Yeah.
May I please the court?
Yes, please.
Ms. Artemis, considering the contractual obligation outlined in the space flight agreement and the relevant law and regulations, can you explain why you failed to disclose your chronic headache during the medical evaluation despite the clear requirement to do so? How do you justify withholding this vital information, knowing it could impact not only your own safety, but also the safety and well-being of other participants and crew members during the space retreat?
Your Honor, I'm slightly confused with the structure of how this is going.
Yeah, I also was a little bit. Ms. Ryford, you just asked some questions. So was that a submission you're making? That was a submission rather than a question, surely. So I think if I've got this right, so your counter so the counterclaim now has to be presented, doesn't it? Formally.
The junior defendant has to open the counterclaim.
Yeah. So was that your counterclaim? Ms. Ryford? Was that your submission on it? Or are you just relying on the counterclaim that's set out in the
Yes,
in
Your
the
Honor.
papers? You're just relying on what's in the papers?
Yes, Your Honor.
Okay, fine. Okay. Is there a response to that?
Since I did not start my submissions, may I just proceed with my arguments?
Yeah, sure.
Thank you, Your Honor.
Counsel, it may be helpful if before you proceed, you just give us a short bullet point summary of exactly what points your arguments are going to be.
Yes, Your Honor. Sure. May it please the court, my name is Kavrisha Shilan, and I'm the junior counsel for the claimant, Ms. Artemis Astrothea, in this case. Your Honor, we submit that the key issue in this claim is whether Ms. Astrothea is liable to Solar Dream Incorporated by way of breaching their contract. Your Honor, I will be addressing the defense to this counterclaim, for which I shall be making two key submissions. Firstly, that my client cannot be found liable for the breach of contract due to the unlawfulness of Clause 5.2 and 5.3 of the Spaceflight Agreement. Secondly, and subsequently, my client's performance was in no breach of the contract signed by both parties, as she had the right to protect her sensitive medical privacy. Your Honor, may I proceed with the first submission?
Yes, please.
Thank you, Your Honor. My first submission regards the nature of the clause 5.2 and 5.3 of the spaceflight agreement. Clause 5.2 states that the passenger declares and represents that to the best of their knowledge and belief, they are not aware of any medical conditions or symptoms of a potential medical condition that may affect their fitness to participate in the spaceflight. The passenger further acknowledges the importance of providing accurate and complete information during the medical evaluation. This clause was enforced by the declaration form which my client was asked to fill and the medical log which asked that she list all conditions she had or is suffering from. Moreover, clause 5.3 states that the passenger undertakes to promptly inform the spaceflight operator if there is any change in their medical condition or if they become aware of any medical symptoms that may affect their fitness for space travel. This includes any changes that occur between the time of the initial medical evaluation and the scheduled launch date. The claimant did not disclose the condition of her chronic headaches, and the defendant claims that non-disclosure is a breach of contract. Your Honor, counsel for the claimant does not dispute the fact that there had been non-disclosure and that by the plain wording of the contract, Ms. Astrothea failed to meet her obligations. However, counsel for the claimant submits that this obligation to disclose any and all information is an unfair contractual term as it constitutes a breach of Ms. Astrothea's personal privacy and thus it is unlawful. Your Honor, allow me to guide you to page 22 of the court bundle to Law Number 5 of 2023, establishing the Dubai Corporation for Consumer Protection and Fair Trade, which may be applied here. Under Article 2 of this law, also found on page 22 of the court bundle, Ms. Astrothea is considered a consumer as Ms. Astrothea is a legal person who obtained a commodity or service by entering a contract in relation to the commodity or service being provided. In this case, Ms. Astrothea had obtained the service provided by Solar Dream, the space yoga mat, through a contract entered by both parties. The service in question is the Yoga Space Retreat experience. This contract required the passenger, Ms. Astrothea, to disclose her medical history to Solar Dream so that Solar Dream could ensure the safety of its passengers for the duration of the space yoga mat experience. As such, the spaceflight agreement falls under the jurisdiction of Law Number 5 of 2023. To expand upon this, Your Honor, if you could look at page 22 of the court bundle, Article 9 of the Law Number 5 of 2023 states that the law's function is to safeguard the security and confidentiality of consumers' personal data and prohibits its unauthorized use for commercial or promotional purposes without obtaining prior consent from the consumers. The duty of confidentiality here is governed by Article 29 of the DIFC Law Number 6 of 2004, titled Law of Contract, which could be found in page 18 of the court bundle. The article states that where information is expressly given as confidential by one party in the course of negotiations, the other party is under a duty not to disclose that information or to use it improperly for its own purposes, whether or not a contract is subsequently concluded. Currently, as it stands, counsel for the defendant claims that it is due to Ms. Astrothea not disclosing her information they suffered a loss. My client's medical history is being used to justify Solar Dream's failure to provide the passengers with a safe and successful mission. This contradicts Article 9 of the Law Number 5 of 2023, establishing the Dubai Corporation for Consumer Protection and Fair Trade, as Solar Dream had intended to use passenger medical history as a method of determining which passengers are fit to travel and would thus provide the most successful results for the space yoga mat experience, meaning that passengers with poor medical histories would be excluded from the experience while passengers with healthier medical histories would be more than qualified to participate in the experience. Your Honor, we would like to emphasize that this strategy of employing medical data may at first glance be seen as a method to ensure all passengers' safety and conveniently meet the national and international regulations and safety protocols. However, Solar Dream stands to make an economic gain from the collection of the passengers' medical information. This is simply because the selection of passengers per their sensitive medical information is done with the aims of providing a more successful flight, safe space flight. As a result, the more successful the flight, the more Solar Dream's reputation grows, and other individuals are encouraged to participate in similar experiences provided by the defendant. This is a personal profit to be gained from the usage of private information, which is the very thing that Article 9 of the Law Number 5 of 2023 seeks to protect vulnerable consumers from. Additionally,
Sorry, Council, may I
yes,
just pause you there? If I understand your submission on this point correctly, you were saying that uh, the defendant has breached law number 5 because they used your client's medical history, or they would have used your client's medical history for economic gain. Is that correct?
right, yes,
But
yes, Your Honor.
in circumstances where your client did not disclose this medical history in the first place, how is this? How is there potential use of this to choose a breach?
My second submission would be including how this information is very sensitive. Therefore, my client expects it to be private and has a right to protect her medical information. However, we also, which is why we're submitting that they're able to gain economically using this information, regardless of how it seems like they are following safety protocols.
Yes, but I mean, you understand that the problem with what you're trying to argue is that
Yes,
the issue of breach or the issue of unauthorized use only comes once they have the information.
right.
In your case, they never had the information to begin with.
Right. We are establishing that the clause itself is unlawful. Therefore, this would not amount to a breach of contract.
Okay. All right.
May I proceed, Your Honor?
Yes.
Thank you. Additionally, this may breach the principle of confidentiality in Article 29 of the DIFC contract law, as medical information is confidential information and it is thus improperly used for personal purposes. Counsel for the defendant may argue that Ms. Astrathia voluntarily signed the agreement to disclose all her medical information, and thus use of her information cannot be improper or unconsented. However, Article 29 of the DIFC contract law, found in page 18 of the court bundle, states that the duty to protect confidentiality stands whether or not the contract was signed. As such, the term may be found to be unlawful, even if it has been signed and agreed upon. To conclude my first submission, Your Honor, the clauses of the agreement that demand that my client disclose all her medical information should be seen as unlawful, as they misuse her private information. Thus, Ms. Astrathia cannot be liable for the breach of an unlawful term. Your Honor, may I proceed with the second submission? Your Honor, may I proceed with my second submission?
Before you do, Ms. Cook, can I just ask one quick question? The private
Yes, Your Honor.
information medical you're talking about, it relates to headaches.
Yes.
That's it.
Headaches that she has been having for consecutively for 5 years. A headache that is being undiagnosed by many doctors.
I just want to get the gist of your argument is that the headaches themselves, even though they may seem trivial medically, they're still sufficient enough to non-disclose for the sake of privacy. Is that your case?
Yes, and also the clause requires her to disclose all her medical conditions, everything. So, which is why we say that it is an unlawful clause.
I got it. Okay.
May I proceed, Your Honor, with my second submission?
Yes,
Thank
please.
you. My second submission is that Miss Astrothea was entitled to non-disclosure of all her medical conditions as she has the right to protect her private medical history. In order to establish this, the information concerned must be private in nature. I would like to draw inference from the common law case of the United Kingdom. Your Honor, allow me to guide you to page 15 of the court bundle to the case of Campbell and Mirror Group newspapers, decided in 2004 and reported in the second volume of the Weekly Law Reports on page 1232. Your Honor, would you benefit from the facts of this case?
I don't think I need the facts unless.
I shall proceed from here then. The court here held that there would be a breach of confidentiality since the public information was of sensitive and private nature. Your Honor, if you could look at page 16 of the court bundle, paragraph 2, line 5, commencing with offensive that since. The court summarizes that details related to the condition of the claimant's physical and mental health and their treatments were akin to private and confidential information contained in medical records. If the court were to take this case into consideration, Ms. Astrothea's medical records may be considered private and confidential in nature, and persons are entitled to protect their private information. Your Honor, to support this, I would like to bring a significant case from the United Kingdom common law to your attention. It is the case of Douglas and Hello Limited, decided in 2003 and reported in the first volume of Entertainment and Media Law Reports, page 28. You may find this case in page 10 of the court bundle. Does Your Honor require the facts of this case?
No, please proceed.
Thank you, Your Honor. Counsel for the claimant brings this case before this court for its test for the reasonable expectation of privacy regarding private information. As already mentioned, medical history falls within the category of private information, and rightfully so, the claimant has a right to protect that information. The question is whether Ms. Astrothea has a reasonable expectation of privacy regarding her medical history as per the case of Douglas and Hello. Regarding the current case, it can be argued that the claimant did in fact have a reasonable expectation of privacy regarding her medical history. Any individual placed in a similar situation may find that they do not feel comfortable providing such in-depth information about their medical histories, because there is no way of knowing whether that information will be used for more than just an insurance that excludes liability from Solar Dream. As such, my client provided a lot of medical information, but she is entitled to refrain from disclosing some of it, as she has the right to protect her private information. In this instance, connecting this submission with my prior submission, the medical history of passengers could have been used as a method of selecting passengers that would increase Solar Dream's success, because healthier passengers mean less failed missions or experiences. In this circumstance, Ms. Astrothea would have the right to protect her private information because there is no guarantee that her medical history would not be used for commercial gain, which is prohibited under Article 9 of the Law Number 5 of 2023 and Article 29 of the DIFC Contract Law. Additionally, Your Honor, counsel for the claimant would like to stress that Ms. Astrothea's chronic headaches were not diagnosed by a doctor, despite her many visits for 5 years, and the contract demands that she disclose medical conditions. Thus, the contract cannot be breached by a medical condition that has not been diagnosed. Yes, the claimant indeed suffers from chronic headaches, but these headaches have gone undiagnosed and untreated for years. Your Honor, can this really be considered a serious medical condition that was crucial information that Solar Dream required, or would this have been information that Solar Dream could have used to exclude Ms. Astrothea from the experience, reducing the arbitrary risk of failure for their economic gain? Counsel for the defendant may claim that the headaches are not such sensitive medical information. However, in reference to Campbell and Mirror Group newspapers 2004, found in page 17 of the court bundle, if disclosure of information about an individual would give substantial offense to them, then that information is private and sensitive in nature. Ordinary sensibilities are of course considered. However, this still means that it is only the concerned individual's reaction and opinion that determines the sensitivity of this information. My client did not disclose her chronic headaches due to fear of adverse consequences, as she would be discriminated due to her mysterious illness that had been left undiagnosed regardless of multiple visits she had to many doctors. This sufficiently proves that she would have taken offense if such information about her would have been disclosed, thus determining it as private information that ought to be protected. To conclude this submission, Ms. Astrathia did not breach the contract with Solar Dream by way of non-disclosure of her full medical condition, as it is private information which she is entitled to protect and hide. In conclusion, Your Honor, the counsel for the claimant submits that the clauses of the agreement that demand that my client disclose all her medical information should be seen as unlawful as they misuse her private information. Secondly, the claimant has not breached the contract with the defendant by non-disclosure, as it is private and sensitive information which she has the right to protect. Your Honor, unless there are no further questions, this concludes the case of the claimant.
I have a quick question, counsel.
Yes, Your Honor.
I see that your client has claimed 7.5 million in damages, in addition to
Yes.
asking for the refund of the money that she's paid under the agreement, right?
Yes, Your Honor.
However, to assist us with quantification, how would you deal with the limitation of liability clause in the agreement itself?
I have not argued that under my arguments for now. I would not be able to assist you with that question. Sorry, Your Honor.
Am I to understand that the case of the claimants is now closed?
Yes.
Or are there any other submissions that we are expecting to hear from you or
There
your
will be
counsel?
rebuttals from the junior defendant, and then the junior claimant will be making some rebuttals.
Okay, but so am I to understand then that the claimants are happy if we apply the limitation of liability clause in the agreement as regards
Yes.
your client's damages claim,
Yes.
which would then reduce your claim to limit your claim to 1 million as opposed to 7.5 million?
Right. But we stand with what we have submitted.
All
So,
right.
thank you, Your Honor.
I think, Ms. Reifer, I think you need to respond, don't you? If I got this right.
Your Honor, may I respond to the question? I would like to know in which it's written that Ms. Artemisia has submitted all documents, and where it's written that Solar Dream have misused that. Because in fact number 8, it's clearly written that Artemis did not disclose her chronic headache to Solar Dream during the medical evaluation conducted before the space flight, despite experiencing chronic headaches for the past 5 years. Artemis chose not to mention this medical condition because she feared it might prevent her from participating in the space retreat. As a result, she did not provide Solar Dream with information about her medical related to her medical history related to her headaches. And in paragraph 9, Artemis has made no mention of her chronic headache because she was afraid that Solar Dream would not allow her to participate in retreat.
Is that your submission?
Yes, Your Honor.
All right.
So I take it we hear rebuttals on this now?
I think it's the final set of
Yes, Your
submissions. Yeah. It's always complicated when you have counterclaims in terms of the order. But
Yes.
yeah, I think it's the last advocate now that we hear from.
Yes, Your Honor. Your Honor, regarding the arguments made by the counsel for the defendant, the counsel for the claimant submits the following. The counsel for the defendant argued that my client hid information intentionally due to the fear of being disqualified. As I submitted previously, my client did not disclose her chronic headaches due to the fear of adverse consequences, as she would have been discriminated due to her mysterious illness that has been left undiagnosed regardless of multiple visits she had to many doctors. This sufficiently proves that she would have taken offense if such information about her would have been disclosed, thus determining it as private information that ought to be protected. Moreover, the counsel for the defendant states that the headaches could not be that sensitive information. In reference to Campbell and Mirror Group newspapers, we submitted that if disclosure of information about an individual would give substantial offense to them, then that information is deemed as private and sensitive in nature. It does not matter entirely whether how others would have reacted to the same manner. What matters is only that this information affects the concerned and how this affects the concerned individual. That is the premise of privacy, as it cannot be determined by the general public. Otherwise, any person's information would be treated as public because another may not have the same regard to their privacy. That argument simply cannot be accepted. A person's privacy must be respected. Moreover, the counsel for the defendant also argued that there is no economic gain from the claimant's medical information. This is incorrect, as it is simply because the selection of passengers per their sensitive medical information is only done with the aims of providing a more successful spaceflight. As a result, the more successful the flight, the more Solar Dream's reputation grows, and other individuals are encouraged to participate in similar experiences provided by the defendant. This is a personal gain that Article 9 of the Law Number 5 of 2023, as I submitted before, seeks to protect consumers from. And this is also a breach of the principle of confidentiality in Article 29 of DIFC contract law, as medical information is confidential information, and it was thus improperly used for personal gains. And even though my client voluntarily signed the agreement to disclose all her medical information, and thus the use of her information could be improper or unconsented, Article 29 of the DIFC Law Number 6 of 2004 states that the duty to protect confidentiality stands whether or not a contract was signed. Therefore, it does not matter whether she signed the agreement on her own volition. Your Honor, this concludes the rebuttals from the counsel for the claimant.
Right. Is there anybody else we have to hear from, or are both parties to the rest?
Okay, so I think that concludes the case. I think I've got that right. Well, thank you to all the advocates. Ms. Sen, did you have any further questions? I didn't.
I didn't have any questions. I just wanted for us to be able to do the scoring sheet. I wonder if you can see what I'm putting on the chat box. Could the teams please assist us with just giving us the information in that chat
I
box?
think, Ms. Sen, do we not have to go into some kind of secret room now?
Oh yeah. But I just wanted just for us to be able to fill in the names of the
absolutely.
So while we do that, we can maybe discuss.
Yeah.
Some.
I don't know if everybody, all the other. What might be easier is, I don't know if all the advocates now can log off, because I think it just leaves the judges now to discuss matters. So I don't know if that's easier now, because I think everybody can log off, I think, can't they? They don't need to be on, do they, at this stage?
I agree. Unless
Bhupender, I don't know if Bhupender's hearing this, but I think now that the case is completed, I'm pretty sure they can just now log off.
Thank you, Your Honor.
Thank you, Your
Yeah.
Honor. Thank you.
Thank you.
Thank you,
very
Your
much
Honor.
for all your
Good
help.
day.
Pleasure. Thank you. Grateful. Well done. Well done. Thank you.
Have a great day.
Thank you.
Thank you.
Thank you so much, guys, and thank you for your time, judges. Okay, so should I also leave, or you can continue with your discussion?
Yeah, I think Miss Sen and I will just discuss matters. I think I can see someone else on screen. Sorry, Dr. Mariam. Sorry, I didn't even say hello to you this morning. We just went straight in. So
Nah, it's okay. It's okay. It's okay. I was assigned as a standby judge, but no one,
Ah.
no one
Oh,
even
we're so
said
sorry. We
anything.
didn't know that.
we didn't even know.
It's okay. And I saw that we have a third judge, so I was just watching. Because my hearing yesterday was cancelled, so I was just curious to hear how this
Yeah.
case will go. Yeah, it's fine. No problem.
But you still judge. You can still do this. She can do the.
Well, yeah, I
Yeah,
can to support this hearing. I can also
Yeah.
share the scoring. Yeah, no issues.
Well, I don't know what you think, Miss Sen, but I thought the claimant presented the case better.
much better. Yes.
I think the skeleton argument was
Was also
better.
better structured than the
It was,
defense.
wasn't it?
Yes.
And I know it's the second junior counsel for the defendant. I thought her manner of submitting was very.
Yeah.
It was more rhetorical in terms of questions rather than making submissions. I thought, but
Yes.
it's early days for them. So I don't know what you think, Dr. Mariam, but I think the claimants are the clear winners of of this round.
I agree. They are better prepared for the oral submissions and the style, the way of dealing with the questions, and
Yeah,
it was a little bit unexpected that the junior defendant she addressed the question, but I
Yeah, it
think
was it was like a cross examination. I was so
yeah. I
confused.
was trying to find the witness. I thought, is other witnesses on screen?
but I think they're just not prepared for the uh,
No,
for this stage of the hearing. So that's why.
no. I thought they did it. They were a bit rushed. I thought. I don't think they prepared it thoroughly. So in terms of scores, I know there's an oral mark sheet. One of us has to do it. I don't have access to it. I don't know, Miss Sen, if you have access to the sheet there, but do we have to give unanimous scores? Don't
Yeah,
we?
it has to be one. It has to be one score sheet. So I'm happy. I don't know if we can. Let me see if I can share my screen. I think there's an option to do that.
Yes, ma'am. You can share your screen. Also, sir and ma'am, we have one more room that is for judges. Judges only for judges. No participant can join. If you want, so you can join that room as well for the conclusion.
I
Okay,
think we're okay
everybody's
here.
here anyway. Yeah,
Yeah, it's too complicated now to.
yeah.
Okay, so if you want to share your screen, just click on the share and go to
Yeah,
the.
let me see. Let me see if you can. I'm not sure if you can see my screen. Can you?
Right now, it is visible, ma'am. Yeah.
But I don't see what I'm sharing. Are you seeing the all around score sheet?
I see something here. Hold on. Yes. So, yeah. Okay. Listen, are you happy to fill that out from your end for all of us, or
Yes, but
it just has to be one sheet, doesn't it?
yeah, it has to be. So I started putting in what I thought, but please let me know if you disagree with that.
Yeah.
Can you see it?
Yeah, I can see it. So 7 out of 10, 8, 8. Yeah.
And then
I mean, usually what would happen, the proper opening would be, I am such and such representing the claimant. My learned friend such and such is representing the defendant. I think both sides missed that in the introduction,
yes.
although they did politely open and they said, if it may please your honor and all the rest of it. So, yeah, I think, Dr. Mariam, I don't know what you think, but I think 7 is right, I think, for the claimant. You've given 7 to the defendant as well. You're very generous, Miss Sen.
I know, but then I saw you scoring for the written for the written submissions, and I was really, really bad with that. So
No, it's okay. I mean, I just thought I'm going to be, yeah, maybe I was a bit, well, no, I think I was fair. Because the skeleton, yeah, there was a big difference between the two skeleton arguments.
there was a big difference, definitely.
I think for organisation, structure, and analysis of the issues, I think the claimant. Do you think they should get a little bit more? The senior counsel. She presented very well, I thought.
Yeah. So do you want to make it 8 or 9?
I'm happy with 9. I don't know what Dr. Mariam thinks.
I agree. It might give them the chance, maybe in the other round. They are good, even if they made this mistake. Maybe they were just nervous.
Yeah.
Give them the chance. Yeah.
And the claimant senior counsel. I thought the senior counsel for the claimant was much more, I think, measured than the junior counsel.
For the defendant, you mean?
For the defendant, yeah.
Yes, definitely.
So I think for her, it's either a 7 or an 8 for her. I think she wasn't. I enjoyed listening to her.
Yeah, she was quite good. Let's make it. I mean, I'm happy to give her an 8.
8. Yeah. Okay. Junior counsel of the claimant. I thought she was very good. I think again, I'm tempted to go for 9 with her. Yeah.
Yeah.
Junior counsel. Yeah. I don't want to be too harsh, but
a 6.
I think let's go for 6. Let's go for 6. It was a good effort, nonetheless. It's difficult, isn't it?
It is.
Use of facts and legal principles. Yeah, I think the senior counsel, she was able to answer questions quite quickly in terms of the facts.
Yes. Though
8 or 9.
I did notice that she did not pick up on all the relevant facts, but that's okay. I mean, they're learning.
Go for 8. I think 8's good for that.
Yeah.
Senior counsel, facts and legal principle. I mean, it was her submission was very short, I thought, wasn't it? It was 7? 6 or 7? 7. Junior counsel, again, I think she's an 8 or a 9, the junior counsel on legal principles. Yeah, I think she'll go for 8, yeah. Again, 6 for the junior, I think, for defendant.
Defendants, yeah.
Yeah. Use of authorities and citations. I think both sides did mention the case law, didn't they?
They did, but the only issue I had was with the defendants not giving us a bundle.
No. Yeah,
which, I mean, really, it made no difference to us, but I mean, in terms of the Moot rules, they're supposed to give us a bundle of authorities.
Right, so shall we do 9 and 6?
Yeah, that makes sense.
And maybe the same with the junior counsel on each side, I think. Persuasiveness and reasoning, yeah, I think. I thought she was very good. I
think 9 or I wouldn't mind doing 10 for both the. For the
I think let's go 10 for both. I think they were both very good. They were both very assured, weren't they?
Yeah.
And then a junior counsel, senior counsel for the defendant, persuasive, and I mean she was
9, 8.
8, I think.
Yeah.
6. Yeah. Presentation and teamwork, I think 10 and 10, I would have thought, or 9 and 9. What's up to you? But I thought they were both very good.
Yeah, I think so too.
Yeah. And then maybe 6 and 6, or 8. Yeah, 8.
Or 7 and 6. Let's make it 7 and 6.
Okay.
Yeah. Okay, that's great. I will add all this up. But I think overall it's clear that the claimants are the winners. So
yeah, I think they were just better prepared, well structured. They split their time properly. I think the other team just struggled to get to grips with what they needed to present. I think it just looked very hastily done.
Yeah, definitely.
With a bit more work, I think they would have I mean, there's a comment section, so I mean, I don't know if we need to do that. It might be
Um,
helpful. It might be helpful to put some comments there, wouldn't it?
yeah, definitely. I mean, maybe I'll just do an overall comment for the claimants and the defendants just to see
Yeah,
their
let's do that.
position.
Yeah, yeah.
And for the defendants, I'm just going to say
Yeah, good effort, but more focus required.
yeah. Sorry, can you see?
Yeah, I can see. Yeah, good effort. Refining the presentation would help. Their counterclaim submissions, I thought, were quite weak. So I think they struggled with the counterclaim submissions. I think generally.
Yeah. Yes.
Yeah,
Okay. Great.
good. Done.
All right, great. I will fill in the rest of this. Could I trouble you both just so that I don't mess up the spellings of your names? If you could just in the chat put in your name so I can just copy paste it.
Yeah, hold on. Why? Yeah.
Perfect. Thank you so much. I can fill in the rest and I will send it over to
Okay.
the
So
DIFC.
that's it then. Yeah.
That's it.
Nice to meet you all. Nice to see you.
Yeah, it was great meeting
It's
you.
very
Nice
fun.
meeting you.
Yeah, really nice. Hope to see you again. Thanks a
All
lot.
right. Have a great
Bye.
day.
Sure, yeah. Take care. Take care.
Thank you so much,
Have a
judges. Thank you
lovely
for your
day.
time,
Yeah.
everyone.
Bhupinder,
Yes, ma'am.
sorry, am I saying your name right?
Yes, yes, yes. It's totally right.
Okay, great. Can you assist me with something? I'm not sure if you're the right person to do this or if I should contact the
Uh,
COS. But what I needed was essentially from the teams, if I could get their council names. So I should have this from the people on who were attendees, shouldn't I?
I
Is that the way I
think
can see
so.
it?
You need the names, like from the council
Of
as well as the
the
respondents.
yeah, but it's here in the parties involved, isn't it?
Yes, exactly. The party you can see. Just click on the button. Just
Mhm.
give me a moment. Let me tell you. Just click on that button, and you can see all over the names who are involved in this particular dispute.
That's perfect, but I don't know.
Yeah.
I don't remember who was the. Okay, maybe let me try.
Okay. Okay. Just a moment. Let me.
Khadija was the defendant's jury counsel, wasn't she?
So you want the name first of all with the claimant side or from the respondent side?
From the claimant side, I want to know who the senior counsel was and who the junior counsel was.
Okay.
We don't need to give them feedback, right? I can just leave at this moment.
I think
Or
so because I think they've left anyway. So
uh-huh. So I can leave, no issues. Or you need any help from my
no,
side?
no, no.
No?
I'm okay, doctor. Thank you so much. What I will do is I will copy you in also when I'm sending it out.
No
Uh,
problem. Sure.
so
I,
that
I'm very thankful. Yeah. Take care. Take care.
all
Yeah.
right. Thank you so
Have a
much.
lovely day. Yeah. Bye bye.
Bye.
Thank you, ma'am. Have a great day.
Yeah, for you as
Just
well.
thank you. Just give me one moment, ma'am. Let me tell you one thing. Okay. Just let me 1 minute. So I can tell you the names, ma'am. who are from the claimant side as well as who can from the respondent side. And also there is one name from the claimant as well as the respondent who are the advisor.
Okay, I don't want the advisor. I just want to know who was the from the claimant side. Who was the lady who spoke first?
Okay, because likewise I have all over the names over here.
Yeah, yeah, yeah. No, I know what you mean.
Okay, okay. So first name is okay. Let me tell you the name. Okay, that is Navya Padukudi is
Yes, she was
from
the
claimant.
advisor.
Okay, and the other one is Zahra Almarhoon,
Yes, but
and we have Kabisha Sholing.
maybe I think the easier way is for me to just leave it as it is and ask the COS Moot team to confirm with the claimants what the names were. Does that make
Yeah,
sense?
yes, it is makes sense. Okay, Marge, should I like invite someone here so he can give you the better answer for this?
Oh wait, I think somebody said this. So they've said they on the in the chat. Somebody said Middlesex University. Senior claimant name was who?
Wait, let me just check.
And the junior claimant was. Okay, that's great. And I needed the names of the judges.
Hello, ma'am, are you here? Hello, am I audible to you, ma'am?
Hi, yeah, sorry, hello. Can you hear me?
Ma'am, did you left the call or it's something else?
No, no, no. Can you hear me?
Yeah, I can hear you, but in the meantime, like you left the call and joined again. So it is
No, no,
like
I don't think so. Anyway, it doesn't matter.
okay. So you can see the chat over your message as well and Kabisha's message from Middlesex University.
Yeah, yeah, yeah. I
Senior
saw
claimant
that.
name.
I saw
Yeah.
that. Thank you so much. I will. How do I stop sharing my screen?
Just click on. Wait. Okay, you
Can you just?
already shared. You already stopped.
Oh, I've stopped sharing. Is it? Okay,
Yeah.
okay, okay. Great. I think I'm done. I don't think I need any more assistance with this.
Okay.
I will just. Can you do me a favor? I think you can help me with this. Is
Sure, sure,
the
ma'am.
third judge, Dr. Mariam?
Okay.
Can you give me her email ID on the chat so I can copy her into the?
Okay, just a moment.
So
Can you see the ID, ma'am?
One sec. Yeah, okay, perfect. I got this. Thank you so much. So I can
Okay.
log out now?
Yeah, you can just click on the leave button and it will like automatically
Perfect.
end the call. And if you want to
Perfect.
log out, so you can do that as well.
Perfect. Thank you so much, Bhupinder, for all your help.
Thank you, ma'am, and have a good day, ma'am.
You too. Bye.
Bye.